Assalamualaikum and salam sejahtera. My name is Muhammad HILMANUL bin Muhammad AZMI. My group and I will be presenting about process of inquiry. Before that, I will introduce Land Acquisition Act 1916. Land Acquisition Act governs the process of acquiring land by the government for public purposes or development projects. Under the Land Acquisition Act 1916, the government has the power to compulsory acquire private land for various purposes such as infrastructure development, public utilities, housing project or industrial development. The Act provides guidelines and procedure to be followed when acquiring land, ensuring the landowner are fairly compensated for their loss. To gain insight into the specific inquiry process for land acquisition in the state of Selangor, 24 students visited the Selangor State Land and Mines Office. We conducted an interview with Mr. Nazli bin Tarifus, the Assistant Officer of the Land Technical Unit of the Enforcement, Land Acquisition and Technical Division. Now I will briefly explain about the process of acquisition. First, the department or applicant's agency identifies the need for land for public purposes or development projects. Second, the proposed land acquisition plan is reviewed and approved by state authority. Third, Gazette notification is published under Section 4 of the Land Acquisition Act, followed by Section 8. Fourth, JPPH will prepare a valuation report. Fifth, the land administration appointed to conduct an inquiry. Sixth, the land administrator makes a written decision in Form G, which is compensation amount to be paid. 7. The acquiring authority is required to promptly make payment of the compensation amount. Lastly, after the compensation is paid, the acquiring authority issues a notice of formal possession in Form K.
Hi and good morning. My name is KHAIRUL bin ABDUL, and today I'm going to present about Section 12, which is inquiry by land administrator. In accordance with Section 12 of the Land Acquisition Act 1960, the land administrator is responsible for conducting a comprehensive investigation into the value of all scheduled lands and determining the appropriate amount of compensation which is, in his opinion, is appropriate in each case. Before making an award under Section 14, Section 12 Subsection 1 allows the land administrator to obtain a written opinion from a valuer regarding the valuation of all scheduled lands. This written opinion assists in the accurate determination of compensation amounts and adds further credibility to the process. After that, in Section 12 Subsection 2, land administrator is to investigate the interests of parties seeking compensation or those believed to be entitled to compensation for the scheduled land. The land administrator is also responsible for addressing objections raised by any interested person regarding the area of the scheduled land. This ensures that all relevant factors and claims are considered during the investigation. Next, in Section 12 Subsection 3, land administrator has the right to postpone an inquiry or any hearing of an inquiry. This provision allows flexibility in the process to accommodate unforeseen circumstances that need for additional investigation before making a final decision. Furthermore, in Section 12 Subsection 4, land administrator shall record all the evidence during the inquiry. This means that all evidence gathered are vital for transparency, maintaining a record of the investigation process, and are based and ensuring that decisions are based on solid evidence.
Assalamualaikum, my name is Muhammad bin Salim. I will explain Section 13. Section 13 requires a public hearing at which landowners and other interested parties can present their compensation claims. Section 13 also gives the land administrator the tools he or she needs to conduct through investigation, gather relevant information, and determine amount of compensation to be awarded to the affected parties. The land administrator has the authority to summon witness to testify or provide evidence in connection with the land acquisition case. Parties that summoned are legally bound to Section 175 and 176 of Penal Code Act 574 as stated in Section 13 Subsection 2. Then, to ensure the decision on the amount of compensation to be awarded is fair and reasonable for those affected by the land acquisition, all evidence presented at the inquiry must be considered. As a result, it will be able to ensure transparency, fairness, and availability of relevant information throughout the entire process of investigation. Let's move on to next presenter.
Hi, my name is Muhammad Azmir bin MD.NOR, and I'm going to present to you about section 14, that are award of the land administrator. On this section, we are going to see the land administrator prepare a written award in a Form G. Form G is a form that we use to issue a written award of compensation after an acquisition hearing related to the land. Once the inquiry under subsection 1 is concluded, the land administrator prepare written award that specify the area of scheduled land, its values according to the land administrator opinion, and apportionment of the compensation award. It will be then officially recorded and stored, and the award are considered final. The awards hold this conclusive and status regardless of whether the person of interest in land attend the inquiry or not. It does not affect the finality and conclusiveness of the award. Under section 37, a person may object if they are unhappy with the award. If the award is differ significantly from exercise, the validity is unaffected. If the land is not higher than a quarter of a hectare or higher than 1% of the area of the scheduled land. And also in this section, the land administrator decide how much it costs to conduct the case, including any valuation fees the value may charge. The land administrator define who is responsible for covering the cost and how much. So, for the conclusion, this section tells you about the property administrator that creates a formal award that is Form G following the investigation that specify the compensation and territories for each person with confirmed interest in the scheduled property. The award is conclusive and serve as proof of the extent, worth, and distribution of the compensation for the land. There are rules governing how treatable area disparities must be, and the land administrator determines how much the process will cost. So I hope it's clear for all of us about this session.
I will explain section 15. Overall, section 15 provide a framework for the land administrator to negotiate and investigate alternative for monetary compensation. By taking into account the unique circumstances of each land acquisition case, this section allows more flexible and tailored solution that can benefit both inquiring authority and affected landowners. In the exchange for monetary compensation, the land administrator may enter into an agreement with a person who has an interest in the land, either whole or in part under this section. These provisions allowed for alternatives to monetary compensation in order to achieve a fair and equitable resolution for all parties involved. Discussion about providing alternative land, project shares, or any other arrangement that can serve as replacement or supplement to monetary compensation could fall under this category. As a result, the terms and conditions of arrangement must be clearly documented and agreed upon by all the parties involved. So, let's move on to next presenter.
Next, I'm going to be presenting Section 16 of the Act, which is Service of Award. Under the Section 16 of Land Acquisition Act 1960, in Malaysia, several important requirements and procedures are outlined regarding the award of compensation and the corresponding notices to be served to interested parties. According to Section 16, Subsection 1, under Section 14 of the Act, requires land administrator to produce and give out a notice in Form H to every person who has an interest in a scheduled land upon the award of compensation. Form H is a document utilized by the land administrator in Malaysia to officially notify landowners about the award of compensation for their land acquired according to the Act. Within 30 days of the award date, the land administrator is responsible for serving Form H to the respective landowners. This form contains essential information such as the landowner's name, the specific amount of compensation awarded, the designated date when the compensation is payable, and a notification regarding the landowner's right to appeal against the awarded compensation. Next, in Section 16, Subsection 2, every notice in Form H shall include an extract from the written award of the land administrator in Form G relating to the land in which the person to whom such notice is addressed has an interest. Agency or corporation that apply for the acquisition must settle the whole amount of compensation within 3 months if no objection related award given by land administrator.
In conclusion, the provided section outlined the procedure for the commencement of land acquisition proceedings, service of notice, conduct of inquiries, award by the land administrator, and the power of land administrator to enter into arrangement. That's all from us for the procedure of inquiry. Thank you for listening.